Call the fourth case on this morning's docket, case number 115602, State of Kansas v. Samuel Chavez.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Samuel Chavez. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a Wyandotte County prosecution for a couple of allegations of domestic violence. The state presented evidence that on August 31st, my client violated a protective order by appearing at Ms. James, his wife's house, and engaged in allegations of domestic violence by going in the house and being violent. And then a second occasion on September 1st, where similar allegations occurred. The state charged Mr. Chavez with a couple counts of aggravated burglary, stalking, criminal threat, and I have some other charges. The jury in this case acquitted Mr. Chavez of all the all the allegations with regard to August 31st, but convicted him of aggravated burglary, stalking, and criminal threat on September 1st. The Court of Appeals in this case agreed with our argument that the evidence as was presented was legally impossible to convict Mr. Chavez of aggravated burglary as charged, and therefore set that conviction aside, and that was not petitioned, so I think that's done. So we are here on this petition for review from the stalking conviction and criminal threat conviction on September 1st.
Was there an appeal issue on criminal threat before the Court of Appeals?
There is, well, that affects it?
Yes.
Yes, and
Yeah,
in
which
fact,
one was
I would propose to take the issues out of order here. And the last issue that's a standalone issue in this case has to do with the introduction of prior bad act evidence,
Right.
which I think does affect the criminal threat conviction.
Okay.
And it's part of why I would choose to start there. In this case, the state put on evidence of the protective order in this case, the protection from abuse order, which of course it did because it was an element of the stalking prosecution in this case. So it was obviously relevant, and we've never contested the relevance of that protective order.
But was there any underlying evidence of the underlying acts that gave rise to the PFA?
The protective order and the itself includes evidence that Mr. Chavez either abused or attempted to abuse Ms. James at some prior point. And that's our real claim here, is that introduction of that evidence is relevant, it's properly admissible, but then is governed by 60-455 because it's prior bad act evidence. It's admissible for a purpose, but the danger is that the jury might use it for an impermissible purpose, like evaluating Mr. Chavez's credibility or otherwise just bias against Mr. Chavez, improper bias. The Court of Appeals in this case said that because the protective order in this case was essentially an element of the offense, that 6455 didn't apply to that evidence at all. And we would assert and argue that that is an overstatement of this court's rulings under 6455. The state in its supplemental brief cited this court's more recent decision in State v. Butler for the proposition that there may be things that are part of the transaction of whatever the offense is, in that case robbery, I think conspiracy to commit robbery. And so there were statements that were made in that case. And this court said, look, those statements were all part of the same transaction as the alleged robbery in this case. The statements that's part and parcel of the one thing, the occurrence. But here, Your Honor, and in other cases, by the way, where the state will be required to put on evidence of something like a prior conviction in a weapons charge or something like that, the state's going to be putting on evidence of bad acts that are not related to the particular occurrence of prosecution. And we would argue that that's exactly what happened in this case. That the previous abuse alleged in the PFA order is not part of this occurrence. It's just prior bad act evidence. It's relevant, admissible prior bad act evidence, but it's prior bad act evidence.
So how would it work? You would go through a 6455 analysis, and wouldn't it always come in anyway because it's part of the charge? So you're not going to preclude the evidence.
Absolutely
You're
not.
so 6455 requires a weighing and balancing of whether you're even going to admit it or allow it to come before the jury. In this case, you're always going to allow it.
Well, you're
How-
conceding that it is 6455 material evidence in the exception to 6455. You're just arguing for a limiting instruction.
Right? Is that what you're arguing for? That's what I was going to get to. A limiting instruction always in these kinds of things.
Yes.
That's your argument, it's just a limiting instruction.
Right.
How would it read here?
There are a couple different ways, but primarily it would be like we do for any limiting instruction. Here's the proper purpose of this evidence. You have received evidence of prior bad acts. And I don't know how specific you have to get on that. You should only consider that evidence for the purpose of determining whether or not the state has proved an element of the crime, in this case, that there was a protective order.
That it did exist.
Yeah,
The existence of a protective order.
yeah.
And not propensity to commit.
Just like,
Yeah.
just whatever the PIC instruction is for 6455 evidence. I'm
It's
not
just-
asking for anything new or novel about that.
It's just odd because you're kind of skipping a bunch of parts of 6455 to get to the
Yeah.
ultimate, like, it is admissible, we're just got to do a
Yeah.
limiting instruction.
Yeah, I'm
That's all
not,
you
and
have.
it's exactly what the court said. I mean, I can imagine some situation, Your Honor, where I would still argue it's more prejudicial than probative or something like that. I'm not making that argument in this
Right,
case.
right.
So it's possible that there would be some similar situation to this where I would still be doing that analysis, but not this case.
Look, we got a lot to unpack here on this case, I think. So I'm going to move you over to the your stalking statute challenge and verify what I understand. You're making that as a sufficiency of the evidence challenge, correct?
Yes.
And are you challenging any of the evidence other than the culpable mental state? In other words, do we have to go through that objectively it would cause fear, that she was placed in fear, all the other elements of the stalking? You're not challenging that. This is just the culpable mental state.
Yes, Your
Okay,
Honor.
thank you.
Our argument is on the statutory argument that when the state, under the statutes now passed by the state of Kansas, the statute says that if the state puts on evidence that a person is acting in violation of a protective order, they're acting knowingly.
That is a little overbroad, isn't it?
I think that's what the statute says.
Well, it says.
I'm sorry, they're presumed to be acting knowingly.
Yeah, it says, would, such person's actions shall be presumed to have acted knowingly as to any like future act. Are you saying that like is broad to include abuse of any kind of contact? Section F1 has a number of acts, that doesn't mean everyone that commits some other kind of act would fall within that presumption, the way I read it. You understand what I'm asking you?
I'm not sure I do yet, Your Honor.
Okay. The presumption only applies to have acted knowingly as to any like future act. And if they committed one kind of act that gave rise to a PFA and then committed another act that would be a violation but wouldn't be the same like act, would that presumption apply? I say it wouldn't. You see what I'm saying?
I do see what you're saying, Your Honor, and I guess I disagree with you that it's that. I mean, when it says lie, I would, and I mean, if I'm wrong about that, and the court will say clearly that that's how narrow that statute is. If the state's ever trying to use that presumption of knowledge in the future, I mean, I'll be curious to see my colleagues' answer to that if they think it's that narrow.
Okay. Let me go to the next step, since we're running out of time. The next step is that. Wouldn't you say that creates, subsection C creates a presumption?
Yes.
And a presumption can be rebutted.
Yes.
And if the presumption's rebutted, then what happens?
then the jury doesn't find that.
Then knowingly is not presumed, but the state still can prove recklessly, right?
Yes.
They can still prove the charge. And so what I'm saying is you're saying that every time there's a PFA served, that they have to prove both knowingly and recklessly. And I'm saying the plain language doesn't set that up the way you're arguing it. If we disagree about like acts, and if we agree that the presumption could be rebutted. So it can be factually inconsistent under your argument, but facially it's not necessarily inconsistent.
I don't know if it's necessarily inconsistent, but it's inconsistent in this case, would be my argument. That the statute presumes that like things, and I would be arguing, and I understand the disagreement, Your Honor, I think now, that by approaching and being there, that's still a like act, that's knowing. And that puts up a inconsistency here, or an impossibility that the state is, because they charge. I mean, if they charged him with knowingly doing this, it would be a different situation. In fact, I think that's why they have that statute that presumes knowledge, or if they charged it as a lesser of some sort, maybe. But that's an argument on that point, Your Honor.
And I didn't understand your argument on the 215202, which says that if the state proves a higher mental state, that it encompasses the lower. And so if the presumption applies, that you say it does,
Yes.
then that's proof, positive here, presumed proof of knowing. Why under 5202 is that not also proof, sufficient evidence of reckless?
Because, Your Honor, it's our argument that this court has already held that a person can't act knowingly and recklessly at the same time. That's a legal impossibility.
O'Rear was before the 2001.
And our argument would be the legislature can't change that reality.
Well, you're really not talking about, you call it legal impossibility, but we have all kinds of legal impossibilities. We have the fertile octogenarian. We have, you can manufacture meth without possessing even constructive possession of any of the raw materials or equipment to do so. We have all kinds of legal impossibility. You're saying it's a logical impossibility to both intend and be reckless.
Whatever O'Rear is.
But the legislature can make it, the law be that way, illogical, inconsistently, can't they?
I would argue no. And I would be I hope the answer is no. I hope that the court would say the legislature can't say,
Well, the legislature can define these terms however they want, as long as it's within constitutional boundaries. And so what's wrong with the legislature saying, again, what they say in 5202C, which is if recklessness suffices to establish an element, the element's also established if the person acts knowingly.
It would be...
That's what they said.
I mean, it would be saying, can the legislature say A and not A? Can the legislature do that? Would that comport with due process for a legislature to pass a statute that says the sky is blue and the sky is white? And I would think that this court would say no. That within the realm of due process, that would be a limitation on the legislature.
What's the due process violation?
The due process violation is that, it's the logic argument that Justice Johnson said, that at some point that the legislature can't say that it's A and not A.
Well, that's not
just not possible.
What the legislature's saying is that there are multiple ways to satisfy this element, the element of recklessness. You can prove recklessness, or you can prove knowingly, and both of those proofs satisfy the element.
But I think the court has said that's a logical inconsistency, that you can't do that, and that the legislature shouldn't be able to fix that by saying we don't care. I had a lot more to say, Your Honor, but I'm out of time.
Can I have one more question?
Yes.
Quick on the other issue about your waive, that you should have been able to have an instruction that you waived your right to enforce the protection. and you make arguments that if you have a civil right, you can waive it and abandon it. But what we're talking about here is a crime. And state of Kansas versus Mr. Chavez. And one citizen can't give consent to another citizen to break the law. Would you agree with that?
Yes, but the difference here, the distinction is that crime in this case relies upon the validity of a valid protective order. And that
but
Ms. James,
the crime doesn't say without consent.
but it does require a valid protective order. And Ms. James is the beneficiary of that protective order in the protective order proceeding.
But she can't extinguish that protection order. It was good until 2015, a year. She can't decide, well, I'm back in love, and so after a month, it no longer exists. She cannot say that.
Your Honor, we would argue that by conduct, if she does conduct in violation of the order in which she obtained for her benefit, that she would be waiving that. Your Honor, I thought about the hypothetical in this case, that if Branson is right, and if this court says Branson is right, a person can go out and get a protective order and then call up that person and say, you know what, I've changed my mind. I do want to see you. And the person on the phone could say, well, you got a protective order. I can't do that. And she could say, you know what, I got rid of the protective order. Don't worry about it. Come over. And then call the police saying he's going to be coming over to my house. He would have no defense in that situation.
Yes, he does. He has the defense of that information because it's not just the contact. There are other elements to the crime, aren't there?
No, if Branson is right, no. And that's what we're arguing. And we're not saying that that's necessarily compelled in this case. All we're saying is Mr. Chavez should have been able to argue it. He should have had his day in court on that. And there's uncontested evidence she contacted him.
As he was charged, one of the elements is that he objectively caused fear or objectively caused it, and also she was subjectively in fear. And that's an element of how he was charged. And that's what I'm saying. The phone call is offered to negate one of the elements of stalking.
That's only one way to do this. That happened to be the element in this case, but it's not the only way to prove stalking.
Okay.
Do we have any further questions? Thank you.
Thank you, Your
Counsel.
Honor.
Counsel, Mr. Chief Justice, Associate Justices, may it please the Court, State of Kansas appears by Assistant District Attorney Daniel Obermeyer. I'll take the issues in which they were presented in the briefs. First, the last issue that we were addressing, the second to last issue that we were addressing, whether or not the stalking statute creates a requirement that the state has to prove a knowing element. Justice Johnson, I agree with your assessment and the Court of Appeals assessment entirely in that. Subsection C merely establishes a presumption of acting knowingly once a person has been served with a protection from abuse order. COA correctly held that it doesn't require knowingly to prove a reckless action. It merely just gives the state that sort of presumption. In this case, the application of that subsection is that the defendant's acting knowingly. And under the new criminal intent statute, which replaced in 2011 the old criminal intent statute, which O'Rear applied, knowledge or proof of a higher criminal intent also proves the lesser criminal intent, and the Court of Appeals correctly applied that.
In the different scenarios, if the presumption applies, all the state has to prove is that there was service of the PFA order.
Yes, for the presumption.
It doesn't matter. Doesn't matter what's in the defendant's head or what they intended or didn't intend or whatever. That raises the presumption. So, and if that presumption's rebutted, then the state can proceed with the charges, but they're going to have to prove recklessly. reckless conduct. Would you agree with
I
that?
would completely agree with that, Your Honor.
So your argument is that the Court of Appeals got it right, that the state never has to prove both knowing and reckless. They just have to prove that the presumption arises or prove reckless.
I actually don't even know that we had to prove that the presumption arose in this case, because the jury instructions, they only address the reckless element.
Okay.
That's what we proceeded on. The statute itself doesn't require us having to prove that this was knowingly done. The statute merely creates that presumption, as you noted and as the Court of Appeals noted.
The jury was not instructed on the presumption?
No, they were not. And again, Justice Lukert, your dissent in O'Rear, I think that the legislature read that and they took it up, and that's partially why we have the new criminal intent statute, specifically the language of proof of the greater intent proves the lesser. You specifically noted how that can lead to absurd results. If a defendant, for instance, says, oh, I wasn't recklessly trying to do this, I was intentionally trying to do this act, have that as a defense. We no longer have that problem. Unless there's any more questions.
Can you respond to your opposing counsel's argument, at least as I understood it, or suggestion that 5202C actually violates due process? Because the state has to pick, is how I understand the argument. State can't do the sort of stacked states of mind where the nesting dolls, where the big one captures all the little ones.
Well, I would wonder where the authority for that comes from. I agree with you, Justice Stiegel, that the legislature does have the authority to define criminal.
Well, tell me why they have the authority.
I'm not aware of any how this violates due process at all, when essentially you're telling the state, if you prove the defendant acted intentionally, that's the highest thing the state ever has to prove in terms of mens rea. So essentially we're making our job harder, the state's making its job harder if it elects to prove that a defendant acted intentionally. It's no longer, I think the state...
Has the state met the elements of the crime if the crime at issue defines the mental state as recklessly? And I know 5202C says that it has, but the defendant is making the explicit argument that that violates due process.
I don't know of any case law that says that would violate due process, for the reason I said, that we're just making the state's making its job harder in trying to...
You're saying that due process is not offended by the state overproving its case.
That is beautifully put, Your Honor, and I will adopt that as my argument. Due process is not offended by the state overproving its case. Unless there are any more questions on that issue.
Can you address how you define like future act in the presumption language?
I think that would apply in situations where the victim is looking for to renew the protection from abuse order and wants to cite another more contact with the defendant if it happens at a later date, to use that in their petition to renew or make it to prove up those types of acts, I believe. I'm not quite sure that it was ever really meant to apply in this context or in just a straight misdemeanor case of violation of protection from abuse order. Does that answer your question?
I'm not sure it does. So I think maybe you're saying that the presumption... I'm not sure I do understand what you're saying. So I think that language is tied to the presumption that, as Justice Johnson was pointing out, and might be a limitation on when the presumption arises. Do you agree with that?
Yes, the like future acts language. I'll be candid with the court. I did not review the case law on that to see what exactly this court has interpreted like future acts to believe. I have no reason to believe that it's anything other than what the PFA was obtained for in the first place. I think that's a reasonable reading of the statute without further delving into it. Regarding the second issue presented in the brief as to whether consent is a defense to stalking, as this court knows, there are crimes where consent is a defense to it. There are other crimes that consent is not a defense to it. In the stalking statute, consent is not a defense to a violation of a protective order. And State v. Branson gives the three purposes for having a PFA in the first place. First, it's for the protection of the victim. That's a fairly obvious one that we all agree with. And it's also for enforcement of protection for abuse orders. It's an order from the court. The dignity of the court has to be upheld. But the third reason, which I think is even more compelling even than the first two, is the protection of society. Because when you have a PFA, you have a prima facie case, if you will, that these two individuals, they can't get along. It's in society's interest to keep them apart. So, and as the Court of Appeals noted, this is a crime specifically affecting government functions, not personal rights. I think it's also a little bit dangerous if the court adopts defense counsel's argument in saying that a victim in a domestic abuse situation can somehow waive the protections which are afforded to the victim from the court by any consensual contact. Consensual contact on one occasion does not mean consensual contact on every other future occasion. In fact, it's experience, I think, from in domestic abuse situations where you have the cycle of violence, there's the honeymoon situation, there's the building, and then there's the explosion. And then that cycle tends to repeat itself. So just because couples have reconciled or they've had consensual contact, the order of the court is still in effect unless it is removed by the victim, or the victim can petition the court to remove that or petition to modify it. So nothing the victim in this case did legally modified the case. There's, again, nothing in the statute which would indicate that this is a defense to violation of a PFA through stalking. I know that counsel in his brief cites State v. Hargrove. That is distinguishable from the situation that we have at Barr. Hargrove addresses invited error as it applies to counsel in a proceeding. Counsel can't invite error and then complain of it on appeal. We all know that. Here, and he applies that to victims. And again, this ties into my first argument that we can't just presume that victims are baiting defendants, people for whom they have a protection from abuse order, into violating that and thus in order to pursue a criminal case. I think that's a very dangerous presumption to adopt. Also, it would imperil other orders, I think, as well. If the state subpoenas a victim in any other case and the victim doesn't want to testify, well, they're ordered by the court to appear, and yes, they are a victim, but it's the state's case ultimately, and it's the court's order. So for those reasons, I would ask the court find that consent is not a defense to stalking. Addressing the third issue, this is probably the most interesting I ever read.
Before you move on the consent, trial counsel conceded that consent is not an affirmative defense, but argued for its introduction as being relevant to the other elements, such as whether the wife was placed in fear. But you didn't argue invited error or preserve any challenge to that. So do we? Can we make anything of that?
As far, I'm sorry, Justice Johnson, I'm afraid I don't understand your question.
You've really waived, the trial counsel won the issue for you, I think, but you didn't raise that on appeal, so we have to look at it anew, or tell me why not. Tell me why the trial counsel didn't invite the error that you didn't raise as invited error.
Well, as you point out, because we didn't raise it as invited error, I think we're precluded from arguing it. Okay. But it sounds to me like, yes, from that portion that you cited, he fundamentally agrees that it's not a legal defense. And if it's not a legal defense, then it's not appropriate for the jury to be instructed on it. I would concur with that 100%. The third issue is whether or not, in this case, the protection from abuse order itself constitutes 5455 evidence. And in the Court of Appeals opinion, they cite State v. Hardwell, which is a federal case from the 10th Circuit, and that applies the federal equivalent of 6455 other crimes or bad acts. What that makes the important distinction, I don't think this court's ever made that distinction except in a very peripheral way. Certainly all the case law that this court has come out with regarding 6455 can be read this way, but 6455 evidence only ever really applies to extrinsic acts that the state's trying to prove, and that's exemplified in the non-exclusive list in the statute itself. So when we have here an intrinsic element that the state has to prove is the existence of the protection from abuse order itself. That's, as in State v. Charles, that's evidence that is so closely related to the events surrounding the crimes that it's at issue for trial. I don't think that you can make a way of separating that.
Is there a difference between the existence of the PFA and the substantive facts that gave rise to the PFA?
I think in this case the facts underlying the PFA were not admitted beyond what counsel cited as brief, the preponderance of evidence showing abuse had occurred. Doesn't get into the specifics of what that abuse was. I don't believe there was any request by counsel to redact that when it was offered into evidence. But again, there was no stipulation.
So you're saying the evidence that came in this case, was limited to the court's recitation that the elements essentially have been satisfied for the issuance of the PFA?
Yes, that it's a standard boilerplate order that they have in Wyandotte County, and that's the evidence that the state proved or showed to prove that that element had been completed, and that's the state's burden always to prove. What good, I would ask the court, what good would a limiting instruction really do in this situation where we're really just drawing attention to the fact that the defendant has a protection from abuse order against him? I realize that's more from a practical defense standpoint, but certainly that, I think, would lend itself more to the evils that 6455 is meant to prevent, saying this is a bad act or reinforcing that, than...
But isn't that the defense option to, because the underlying purpose of 6455 is not to use propensity evidence. He did bad before, he must have done bad now. And so the limiting instruction that says you can't use that for propensity, while maybe being theoretical only, just like we say you can only use it for preparation, and then we have 12 million pages of law journals written on what preparation is, and the jury doesn't understand what they mean. But nevertheless, theoretically, if the limiting instruction, if nothing else, can say you can't use the fact that an order indicating that he cannot abuse his spouse can't be used as an inference that he has a propensity to commit abuse over and over again. I mean, that's simply what the limiting instruction is aimed at, isn't it?
It is, Your Honor. In this case, again, the distinction is this is an intrinsic element of the offense itself. I think that the logical conclusion, if the court finds that it is appropriate to give a limiting instruction, this is well, we're giving limiting instructions on every single element, which is, I would submit to the court.
Only those elements that are approved with specific acts on a prior occasion that are being used to infer a propensity to commit this one, and that wouldn't be every element.
And that's why I'm not sure I understand the authorities that you cite, how they apply here. Because aren't they focused on the language of 6455, which is that if you're trying to prove on a specified occasion that bad act or crime occurred, that you can't look at crimes or civil wrongs on another specified occasion? And so those cases are saying we're looking at the same specified occasion, but here you're looking at two separate specified occasions.
Well, to answer that question, I'll pose a hypothetical situation, I suppose. Let's say that the protection from abuse order had been gotten an hour or minutes before even the criminal conduct occurred. Would the court then hold that this is 6455 evidence, or would it be it's so closely related to the acts committed as to be part of the whole transaction? I don't think that making a temporal distinction really serves much of a purpose here.
But isn't that what the statute does by saying at another specified occasion?
And here I would argue we don't really have a specified occasion. There's nothing to say that this specific thing happened on this specified date. It just says by a preponderance of the evidence, court finds abuse under the statute. I'm paraphrasing, but that's essentially what it says. I see that I'm out of time. If I may just summarize, unless there are any other further questions from the court.
I'll grant you 30 seconds.
Thank you, Your Honor. Would ask the court to affirm the Court of Appeals on the first issue because it does not present, there is no legally impossible crime of which the defendant was convicted. The statute does not mandate conflicting mens reas. Also, consent is not a defense to the crime or to a PFA. A victim cannot waive the order of the court meant for society's protection by consensual contact. We would ask the court to affirm the Court of Appeals didn't rule on that, but we'd ask the court to make that ruling. And also on the third issue, we'd ask that the court find that 6455 evidence is not applicable, even if, arguably, as in this case, there is a prior crime or bad act, when that prior crime or bad act is intrinsic as an element to the crime charged. Having said that, Your Honors, I would ask that the court affirm the Court of Appeals. Thank you.
Do we have any more questions? Thank you, counsel.
Your Honor, my only point on rebuttal is just to follow on my friend's last point. Even if I'm completely wrong on the 455 issue, as I so often am, the state and the Court of Appeals point here is if it's an element of the crime, then I guess this evidence comes in without limitation. But it goes back to Justice Byers' question at the beginning of my argument. It's not an element of criminal threat. And so even if I'm completely wrong and the Court of Appeals is completely right on their logic, it doesn't apply to the criminal threat prosecution in this case. And a limiting instruction still would have been appropriate. It is sometimes the case that evidence is even admissible for one count and not another. And so even if I'm completely wrong and you completely adopt this broad view of admission of evidence that the state is suggesting, it wouldn't apply to criminal threat in this case. It would still be error with regard to the criminal threat.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.